Can anyone hear me? You guys can hear me. Oh, we're doing it? We're live? All right, I think we're on. Great. Okay, sorry about that. You can imagine my surprise when that didn't start right away. Wow. Okay. So here we are, live streaming condo log, right? Please put your questions in the chat. I can read them. I can see you all. So that's great. While we're waiting for those questions to come in, I'm going to start with the FAQ. And let's just go to that. Okay, whoa, first question already from Victoria. Can you clarify what options obligations corporations have when aware of a resident who has a requirement to self-isolate? Where is the reason to believe they are not going to, where there is reason to believe they're not going to do so? Oh, okay. All right. So backing up on that idea, first is the idea that you would want to notify residents if you have a confirmed COVID case in the building. You would do that with like posting a notice, and it's just to let people know that the common areas, as much as we try to make them safe for everybody, that people need to use precautions and treat the common areas as if it is, really an outside area, and to, wash their hands before they enter the common areas and to wash their hands when they get back into their units. So if someone should be self-isolating, context is everything, right? Are they totally healthy and self-isolating because they are returning from vacation? In which case, we see people like that going out and walking their dogs and going to the grocery store. And my understanding is that those types of essential outings are acceptable. And then you have people who are like sick or had close contact with someone who's COVID positive and they're like ignoring it. And so depending on the activity and depending on the person, we have to use a different approach. So I would say for someone who's just going out for essential things, that's fine. And for someone who's totally ignoring a requirement to self-isolate, you'd probably want to be writing to them and saying that our expectation is that you will act in a certain way. So yeah, I hope that answers your question, Victoria. It really does depend on the context. Giovanna, thank you so much for taking the time to hold this live stream. Can you kindly advise if a corporation may restrict visitors to suites? Yes. Okay, that is on my list of frequently asked questions. So when I wrote this, the 5 days ago, which seems like an eternity, I had determined that it didn't seem right to me that you would restrict visitors if they are lawfully allowed to be there. We're talking about visitors to people's units, right, which is their home, because we have to respect people's property rights. And the condominium corporation is really only responsible for governing the shared areas and, and for things that people do in their home that are a nuisance to others. But if someone's having a lawful visitor in their home, to me, that's okay. So I'm not a big fan of restricting visitors. I know some condos have done it. There are examples where you could. So one example where you could is if you have a vulnerable population, perhaps you have a condo that's like adult lifestyle. Another example where you could restrict visitors is if you're connected to a retirement home. I know there's a number of condominium corporations that have those kind of shared facilities. Where else could you restrict visitors? There's a bunch of other cases, but you're looking for some sort of special circumstance for restricting visitors. You wouldn't automatically jump to that. I know some condos have actually had multiple COVID cases, and so they're feeling the pressure and wanting to restrict visitors so that things don't get any worse in that particular building where you've got like a really bad outbreak. You might want to restrict visitors because it's actually also just not safe for the visitors to be in the building. So restricting visitors, again, case by case, you want to be careful about that. Not something that we recommend for all corporations at this time. If there's a shelter in place order that comes into effect, then that's going to be different. So once you have a shelter in place order where it's like, no one leave your homes, which we don't have. We have closure of essential businesses, but we don't have shelter in place. You get shelter in place, things are going to change. Next question. Perhaps something similar. What should a management firm do? A resident has COVID. You should notify all the residents, and that's really the main thing that you have to do. If you get it, you should be informed from public health. If someone lives in a multi-dwelling building and they have COVID, public health should be informing the property manager. I don't know if that's happening all the time, but it should be. So you should be getting notice from public health that you have a case in your building, and then you should be posting a notice. Yesterday, Ford said that if you traveled outside the country that you must isolate for 14 days. This contradicts what I just said. No, it doesn't. We're talking about what you mean when it says to self-isolate. So the obligation to self-isolate does not necessarily mean the obligation to remain enclosed in your unit 24 hours a day for 14 straight days. Someone who is self-isolating is still allowed to go outside to buy essentials and walk their dog and those kinds of things. Next, can the corporation rely on the Attorney General's order to suspend limitation periods to allow the corporation to work with owners whose accounts have fallen into arrears? We are getting different opinions. Yes, very good question, Tracy. Okay, so this is another thing I wanted to talk about. And I see Rob Buckler, does the state of emergency loosen the 90-day lien requirements? Okay, similar question. So to answer this question, we have to know what is a limitation period. And so this is a legal term of art. And a limitation period is a specific period of time within which a plaintiff, so in this case, someone looking to collect money, the condominium corporation, must commence a legal proceeding. And if you do not commence your legal proceeding within the time period, normally 2 years, but there are different limitation periods, but the most common one is 2 years. So if you do not commence your lawsuit within 2 years, you lose the right to sue. A lien is not a debt obligation. The debt obligation is the obligation to pay the money. So if someone doesn't pay their common expenses, you have 2 years to sue. That 2-year limitation period is being extended. So from March 16th, it's like if you had until the end of March, when March 16th hit, you had 2 weeks left to start your lawsuit. Now that 2-week period is like extended, and when the when the Attorney General's order ends, you'll still have your 2 weeks. So getting back to what I was saying. So you have these things called limitation periods. The limitation period to sue, if you're owed common expenses, is 2 years. The time period to lien is different. You have 90 days to register your lien, or else your lien expires. But the lien is not the right to sue. The lien is just security. So the lien, all it does is it attaches the amount of money to the property. So it's no longer personal to that owner. It attaches to the property itself, and it puts you ahead in priority of the first mortgage if you do your lien properly. So just because you lose your right to lien if the 90 days expires, it doesn't mean you lose your right to sue for the money. So because liens are security and not limitation periods, it is my view, and I think I know that it's controversial, but it's my view that the suspension of limitation periods does not affect the 90-day time period to lien. So what can you do with owners to try and help them and provide some leniency? Some condominium corporations could pass an amended budget. An amended budget would actually change the amount of maintenance fees that are owed, and that would affect all owners. The other thing is there's nothing that stops you from entering into an agreement with an owner on a payment plan or anything like that. If you have someone who's, in a case of personal hardship, and you would just want to make sure that it's drafted properly so that the corporation's rights are protected. And that's basically what you would do. So can you do things to help unit owners? Yes, you can, but you should still, in the ordinary course, register your liens. And that doesn't mean enforcing them. It just means you put the lien on title. You're secured. You're not going power of sale, of course. You're not taking any steps to enforce the lien right now. You're just leaving the lien on there so that the condominium corporation's interest is protected. And then when things calm down a bit and life starts to return to normal, we can start to talk about what to do about all these liens. And you can do things like waive the interest and even try to reduce the legal costs so that the owners aren't having to pay any kind of penalty and they can just pay back the condos over time. Is there a problem with the audio? Oh, and then someone says, I hear him loud and clear. Okay, I'll try and sit closer and talk loudly so you guys can hear me. Let's see, what other questions do we have? I heard last night that a corporation is obligated to disclose a COVID confirmed case of an employee to the Ministry of Labor. Is this true? If you believe that the employee got COVID at work, then I would say, yes, this must be disclosed because it's like a sort of a form of workplace injury. But if the person got COVID somewhere else, or so you believe, then you're not required to report to the Ministry of Labor if someone suffers an injury, just only if they suffer a workplace injury. I hope that answers your question. Thank you. I'm not a fan of restricting visitors either. Great. I agree. Is it possible to stop visitors and real estate viewing? Visitors already answered. I'm not a fan of it. Real estate viewing, great question. I had this question come up recently. So I am of the view that in-person real estate showings should be suspended and unless they are absolutely necessary. So this opinion is consistent with the RECO, the Real Estate Council of Ontario. If you go on their website, they have like a COVID policy. They updated it on Monday. I'm not sure if they've updated it again since then, but they are recommending that realtors do not give open houses, certainly, which most condos already prohibit, and that they do not do in-person showings unless, quote, absolutely necessary. So what's an absolutely necessary showing? It might mean someone who is like a probable buyer and they've already viewed the property and they've had price negotiations and now they just want to go in and take like a final look at it. So in those very, very rare circumstances, you want to try to accommodate people, but you do not want a lot of people coming and going through your building. You especially don't want people who are coming and going through lots of different buildings. It's not safe for your residents. It's not safe for the people viewing the units. It's not safe for the realtors. Realtors have other options, and they're being encouraged by RECO and by TREB to do virtual showings. So I think it is proper to prohibit real estate showings, but you would have to make exceptions for certain cases where it's absolutely necessary. Can the corporation continue registering liens on non-payments? Yes, you can continue to register your liens. You should do so with as much compassion as you possibly can, but in certain circumstances, yes, you should register your liens. Is the government going to extend the timelines for performance audits, deadlines, budget deadlines? They've extended provincial statutes. Does it apply here? I think you're saying they've extended limitation periods. I think the CCI legislative committee is working with the government to try and get the performance audit deadlines extended. I don't know if that's happened yet, but people are working on it. Until you hear otherwise, assume that the deadlines remain in place and try to get your performance audits done. Engineers are considered an essential service, and so they're still doing their work. But if you can't get it done for reasons relating to COVID, and no one's going to say that you are, you lose your carry-on rights. I mean, I can't imagine that happening. So I'm hopeful that a formal extension will be announced, but try and get it done until that happens. Budget deadlines, like your year-end budget for the corporation. If you don't pass a new budget, you should assume that your current budget remains in effect. If you're having trouble getting your corporation's like next year's annual budget done, then you might want to just approve, at least on a temporary basis, that the current budget remains in effect. And then you can pass a mid-year budget to adjust it. So for example, if you were going to have a 2% increase for your 2020, 2021, and your new fiscal year starts, say May 1st or something, and you don't want to have to deal with your budget now, just leave your budget as it is. And then when you get to 6 months, so whatever that is, like October 1st or November 1st, and you can do a half-year budget and do a 4% increase, and then that's the same as your 2% increase would have been over 12 months. So that's what you can do. Let's see, more questions. Changes with respect to mortgage payments. I'm wondering if there has been any change with respect to common element fees. No changes yet with respect to common element fees. They continue to apply, and people have to pay their maintenance fees. Condos have to pay their bills. They have to pay their utilities, all these things. So yeah, the mortgage deferrals and everything does not affect people's maintenance fees. Are the provisions laid out in the Condominium Act re common expenses still applicable? Is there any government legislation with respect to fee deferrals? Common expenses still paid. There's no government action yet saying to stop paying maintenance fees. Let's see again. Sales representatives are still doing open houses. Does management have the right to stop such an open house in the building? Yes. No open houses in your condos, please. You absolutely have the right to stop that. You should do it by way of a policy and notice to all owners. So if you need that kind of a policy, let me know and I will fire one out for you. But yes, do not allow open houses. It should be banned in your rules anyways. And if it's not, time to pass a rule. I mean, not immediately, but in the future. More stuff about realtors. I think I've already answered all that. Primarily to insure homeowners. Okay. How long will the condo board be able to stop all tradesmen except for emergencies in doing renovations? Okay, so this is also one of the frequently asked questions about what to do about renovations, both in suite and on the common elements. It's my view that all those renovations should be postponed. When you look at the list of essential businesses, construction is included, like home construction is included as an essential business. I'm not sure that would include like in-suite renovations if they're clearly like aesthetic and non-essential. If someone has an ongoing renovation, like they started and then COVID happened and now they have to finish so that they can get into their unit, I would try to allow those people to finish as quickly as possible and then get out of there. No new renovation project should be approved on the common elements or in the units until basically, the state of emergency is over. That's the idea here, is you don't want people coming and going unnecessarily. Those contractors, working shoulder to shoulder, as Mayor John Tory says, should be going home and not on the work site. And I think they announced that, on some major construction projects across the city, they've had COVID cases. So we want to keep the contractors out of the buildings as much as possible. I have an electric vehicle trying to install electric vehicle charging station in the common area garage. The board already approved. The building manager treats as major building renovation. Reasonable? No. So there is a special regulation pertaining to electric vehicle charging systems and how they are to be treated. The regulation is a little bit tricky to read, but there's more information about it on the Condominium Authority of Ontario website. I suggest you take a look. It's a very complicated subject. It depends if you're putting the charging station on the common areas for everyone to use, or if you're putting it in your own parking space. If I'm assuming you're talking about putting it in your own parking space, the rules are very favorable for unit owners, and they basically have to let you do it, especially if there's no cost to the corporation. So yeah, can AGMs be postponed beyond 6 months? Yes. Yes. So we're in a state of emergency. There's a government order not to have gatherings, social gatherings of more than 50 people. I don't know if it's been reduced, but last I heard it was 50 people. So that would cover a lot of AGMs, and even if your AGM would be smaller than that, you should still not be holding it. It's not safe. And I could go on at length about this, but the short answer is yes, you can postpone your AGM. And it's as a matter of fairness, because people have the right to attend the AGM. And if you call the AGM and people don't attend because they're like self-isolating or they're sick or all these different things, then they've lost their right to participate. That's not fair to those people. So you have to postpone the AGM. For real estate showing, should we ask agents to contact the building manager and make an appointment? And should the owner of the unit accompany them? I think they should be by appointment if you're going to allow them at all. And I'm not sure that the owner of the unit should necessarily accompany. The goal here is for social distancing is fewer people. So I would say appointment's a good idea, because then you can make sure that everything's being done safely and you don't have lots of people coming and going. Should the board approve a written payment plan for arrears and the payment plan extends past 90-day lien period? If the owner defaults on that plan, can we still enforce via lien? Oh, that's a great question. I think you can if the agreement is written properly. There are lots of things that you can do and people can consent to. So I would say that you can do a payment plan with an owner, and you can make a term of that payment plan that in the event of a default, it will be treated as the date of default being when they breach the plan, right? So that means that as long as you register your lien within 90 days, it's actually 3 months, not 90 days, within 3 months of the breach of the payment plan, then you're in time to lien. So that's how you would do it, and I think that that's okay. Just make sure you get it drafted by a lawyer so that all the right language is in there. Concierges provided masks, gloves, etc., self-distancing, and front doors locked and allowing entry carefully. 2 concierges are not coming in. Do we have to pay them? Okay. I don't think you have to pay them if they're not coming in. They have the right not to come in, I would say, but they do not have the right to be paid if they're not coming in. Does the board and management have the right to put renovations on hold? Yes. For renovations that are sort of midway through, you want people to be able to use their units. Like if someone doesn't have a bathroom or something, that's a big problem. They need to be able to make the units habitable, but no new renovations. That's totally reasonable. Nick Lombardi, hey buddy, thanks for hosting this, much appreciated. How will this affect AGMs that need to be held? Postpone your AGM. Thank you. Paulette, I'm sorry I missed your introduction. Who are you? That's a great question. Who am I? My name is Bradley Chaplick. I'm a condominium lawyer. I work at Horlick, Levitt, Lella. I've been here for about 2 years, and I've been a condominium lawyer for about 11 years. And before that, I was doing condo law while I was articling and all these things. And I've litigated and I've given corporate advice to condominium corporations my entire career. And yeah, I've been to the Court of Appeal and the Human Rights Tribunal and the Landlord and Tenant Board and Divisional Court, Superior Court, Small Claims Court, everything you can do with a condo in Ontario, I've done it. Robert Buckler, what about garage restoration project? Okay, so is it a shared garage? That's an important question. Assuming it's not a shared garage and it's not a shared facilities decision, and you can try to work it out with your contractor if you've already signed a contract to postpone it. Hopefully you can. If you haven't signed a contract yet, then don't sign one and postpone it. But if you signed one and you need to now change the terms of the contract, that's something you need to agree to. You both need to agree. I suspect that you both would, and then you can postpone it. Do you have to? I'm not saying you have to, but if you can, you should. Can we stop people delivery advertising, flyers, junk mail? How do you mean? What do you mean by that? And who are the people, and where is the junk mail going? Probably, but I need more details. It's hard for me to know based on that. Yeah, you can probably stop that. But we got up to how. I mean, I need to know more about it. So you can either type that in or you can send me an email and we'll talk about it. Can we stop the builder to complete deficiencies and postpone later than the Terrian warranty? You can enter a repair extension agreement. This is for Fabio's question. So try to do that, repair extension agreement, and that gives the builder more time to complete repairs, and that's what you should be doing. So repair extension agreement, talk to your engineers about it. They'll be able to do that for you. What if somebody is renovating in a condo to flip the property, not move in? Should they be able to finish or wait until the non-essential use is lifted? Okay, so this is Cheryl's question. I'm more concerned about people who are renovating so that they can move in and allowing those people to finish. Someone who is renovating a condo in order to flip it, I question even whether that would be considered a essential business that has to stop. So I would try to take the position that this is not an essential business. They have to stop and get out of there. And because it's not necessarily home construction, if they're not building something new, and I would ask them to stop, especially if it's causing a lot of noise for the people who are home. Same with audit being delayed. This is from Robert. Delayed audit inevitable. Please clarify on this delay. As far as I know, the auditors are still doing their audits. It might be that they can't finish the audits because they need records and things like that that are not readily available. So that's going to depend case by case. And if you can do your audit, the auditors are sitting at home doing audits. You know, I've spoken to some of the top people doing audits, and yeah, they're working from home and they're not going to AGMs, but they're still doing their work. And accounting professionals are considered an essential service, and they're allowed to operate, and they are allowed to be in their office if they so choose. So are property managers. Get Quorum is trying to arrange virtual AGM. Is that really necessary? I don't agree with virtual AGMs. I think the Condominium Act is quite clear that people have to have the right to appear in person. So I think a virtual AGM is not acceptable, and it breaches people's rights to appear in person. You can have virtual AGM as an option for attendance, but you cannot have an entirely virtual AGM where attending in person is not an option. Does that answer the question? I hope it does. We've asked investor renovations to stop their work. What can we do if they don't? This is Ron Britt's question. You would send them a legal letter to stop, and you would deny them access to the property. And you would even consider notifying the authorities if their work is not considered an essential service and they're supposed to close down. So let me know. Let me know if you're having problems with contractors who you've told to stop and they're not, because I think you can stop them. In regards to an extension agreement for warranty, should Terrian be involved to approve it? Talk to your engineers. This is Fabio's question. Talk to your engineers about warranty extension agreements. I believe the Terrian rep is involved in them, but your engineers will know the question to that right off the top of their head. I don't know. I'd have to check. So check with your engineers. This is really helpful information. Thank you. If an AGM is postponed with proxies for quorum, is a new pre-AGM package required? Is a complete new AGM package required, or only the changes in new proxy? Oh my God. Okay, lots of stuff here. This is Roz's question. So By the way, we're hitting 30 minutes now. We're going to try and do another like 20 minutes, maybe. I think 50 minutes is like a long stretch here. And then we'll take lots of questions and we'll do another one of these. But we're going to try and cap this around like, I think, shortly before 1 o'clock. Okay, AGMs. So what are the rules? The rules for AGMs are you send your notice of meeting, and then you can adjourn your meeting and continue to use your proxies for the continuation of the same meeting. That's the basic idea here, right? But in your case, you're never starting the meeting. So the best thing to do, in my view, if you've already sent out your pre-notice, like your preliminary notice of meeting, but you haven't sent out your notice of meeting package, is I would just send out a letter saying, we're not going to be holding the meeting as planned. The preliminary notice has a suggested meeting date, but in fact, you can change it on your notice of meeting. So if you've already sent out your preliminary notice, I would just send a general note to owners saying, I know we sent out the preliminary notice, we're not going ahead with the meeting, we're not going to send out the notice of meeting package yet. And then that will cover that situation. If you've already sent out the notice of meeting package, and now you're going to postpone the meeting, I would think the best practice is to send out a new notice of meeting package with all the stuff again. And then you would say in your new package that you'll accept proxies from either package, like that both can be used at the meeting. And you would just make that explicitly clear in your information circular, saying that any proxy that someone brings in, whether it was for the original meeting date or this, they'll both be treated as valid. And I think that's the most fair thing to do. Hope that answers your question. Very, very tricky question. It's going to depend on your timing. I couldn't find anything on the CAO site. Is there any change in the timelines for records requests? Is the tribunal still operational, or is everything on hold? The Condominium Authority Tribunal is still operational. It operates entirely electronically, so it's sort of like a work from home situation anyways. As far as I know, the timelines within which to respond to records requests remain in effect, although obviously if people are requesting records in paper format, then you might not be able to provide them because your office might be closed. And also, if someone is requesting a record, it just might be that your response to the person is, we cannot provide this record at this time because of COVID. And that is an acceptable response. And if an owner were to take you to the Condominium Authority Tribunal saying that you failed to provide the record, you would say, no, I failed to provide it because of COVID. This is a reasonable excuse within the meaning of the Condominium Act, and then you would succeed, I suspect. So you should still respond to people's requests, and you should still provide them with records that you're able to provide them with. And for the ones that you can't, because it's not practical, you would just say, we can't right now, and we'll get them to you later. And that is an acceptable response. So that's what you do with records. Okay, Debbie, as a nonprofit, can we use the reserve fund money to pay operating costs if we are short funds due to non-payment of common expenses, assuming monies will be put back into reserve? Okay, I will give you an alternative. You cannot take the money out of your reserve fund and put it towards operating, but you can postpone putting the money into the reserve fund. Do you see the difference? Once it goes into the reserve fund, you can't touch it for your operating costs. But if in your budget, you're supposed to put, $10,000 a month or whatever into the reserve fund, and you just don't, and you use that money for your operating costs, then you can put the money in at the end of the year and still be technically complying with the obligation to pay the money into the reserve fund each year. So I would say just delay putting the money in, use it for your operating, put the money in at the end of the year. Once it goes in, you can't use it for operating. Bogdan, can you answer the question on using reserve fund money for operating? I think I know the answer. I think I just did. How can AGM be postponed? How can the AGM be postponed? You just don't send out the notice of meeting, and you send a notice to owners instead saying that we are postponing the AGM. That's what you do. And if you have a very, very specific question about what to do in your specific condo, this is for YCC 204, just send me an email, and I will give you more specific guidance. But basically, you just don't send out your meeting package, and you send a note saying you're postponing the AGM. Okay. So we've talked about the limitation periods. We've talked about construction work, and we've talked about realtors. Something we haven't talked about is short-term rental. So that question hasn't come up yet, but I've gotten it a lot, so I'll answer the frequent question about short-term rentals. So there are some condominium corporations that have in their governing documents provisions in their declarations specifically permitting short-term rentals. So these are buildings that were constructed and intended to be used in this way. And leaving aside the City of Toronto bylaws and principal residence requirements and all that new stuff, it is my view that if you have a condo with like 100 units using Airbnb right now and all that stuff, it is within the authority of the board of directors to temporarily prohibit short-term rentals. And this is going to be very important for certain condominium buildings. For some of you who don't have this going on in your building, it's not going to be important. But for condos that have a high usage of Airbnb and other similar hotel-like uses, you can temporarily do this. You want to make sure, of course, it's done properly with notice to everyone. But yes, we're doing this. We're doing emergency policies for condominium corporations with high usage rates of Airbnb, temporarily suspending short-term rentals, which are defined as anything less than 28 consecutive days in the City of Toronto. City of Mississauga and the other GTA municipalities have their own rules, but almost all of them have rules about short-term rentals. And so if you want to do that, let me know, and we'll do it for you. If a corporation applies for a line of credit or overdraft protection, can they do so without a borrowing bylaw? So some condominium corporations have in their bylaws a provision allowing certain limited, like overdraft protection, line of credit type borrowing. Some of them say up to 1 month's budget, like common expenses total. For those condos, they already have it in their bylaw. And for those that do not, they cannot. So the answer to your question is you need a borrowing bylaw to do this, but you might already have one because for many condominiums, it's part of their standard bylaws that they were provided by the declarant. So you got to check your bylaws, and if you don't have that in your bylaws, then don't do it. But if you do have it, then go for it. Measures for condo to prevent spreading COVID. How can we manage visitors legally? Okay, so yeah, we answered this right at the beginning. I'll touch on it briefly again now. By the way, after this is over, this video will remain online, and you can go back and watch the beginning if you missed it. I am not a huge fan of saying no visitors in condominium buildings if the visitors have the lawful right to be there. There's lots of good reasons why people might have visitors. You know, they might be providing, for example, childcare for people who work in essential jobs, all sorts of things. So I would be wary of interfering with visitors. And I think you want to try and trust people to make good decisions about who is acceptable and safe to have visiting the condo. If you have a specific vulnerable population, that's different. For example, if you've got like older population, or you're connected to a retirement home, or you've got a lot of you're managing a lot of COVID cases in your building. So try to take it easy on the visitors. In commercial condos where most non-essential operators are closing, can we deal with the few remaining units open? Can we close the whole mall? If someone has a essential business, so for example, like a pharmacy in your mall, they should remain open. So don't close your whole mall if you have essential businesses in there. They're essential for a reason. That's my best answer. Lots of thank yous. Oh, you're welcome. Okay, so oh, here's one that came up on the list of essential businesses. Much to many people's surprise, home daycare is on there as an essential business. So some of you might be thinking that you've got illegal home daycares operating in your buildings. Just know that on the list of essential businesses from the province of Ontario, home daycare services for less than 6 children was included as an essential business. They are allowed to keep operating even though licensed daycares and schools are closed. Once again, this is important because there are people who work in essential services and they might need childcare. So we want to allow those people, nurses, doctors, to go out and do their jobs and let their children be taken care of by people who are staying at home. So we want to try and facilitate all those things so that essential jobs can still get done for people who have children. In case you haven't noticed, this is my son's room. It's the crib in the background. So my kids are downstairs having lunch right now. All right. Okay. Couple more questions and then we're going to call it, I think. You've all heard enough of me talk, right? I want to thank everyone for chiming in with your questions. This has been amazing. This is like way more questions than I thought we were going to get. There's been pretty consistently, I think, at least 100 people involved in this. So that's really great. Thank you all so much. And I'll just take a few seconds here to see if another question pops up, and that'll be the last one. And if not, then we'll see what else we can do. You know what I'll do very quickly? I'm just going to run through here and see if we missed anything on our update. Okay, we didn't talk about requisitions. If you get a requisition, try to resolve it with the requisitionist so that you can postpone the meeting. Very tricky situation. You want to get legal advice right away if you get a requisition for a meeting of owners. Board meetings. We didn't talk about, no one asked about board meetings. It's my view that all in-person board meetings should be suspended. Instead, hold your board meetings by teleconference. If teleconference isn't possible due to an emergency and something has to be done via email, ratified later, that's okay. Close amenities. No one's asking this because it's obvious. Yes, you can. Is that everything? I think that's everything. All right. Thanks. I will contact you. Are you still answering the phones? Send me an email, bchaplick@hldlawyers.com. If you call me, I am not answering my work phone. I have my cell phone on, so I can talk to you, but send me an email. Breaking news from federal government. Oh my, really? Do I have to check this right now? Hold on. Mandatory quarantines for international travelers kick in at midnight from the health minister. Okay. Well, there you go. Mandatory quarantine. So I'll see what that means, and we'll write about it and keep looking out for stuff from us. And yeah, we will keep doing these, and we will keep updating everyone. And thank you all again. And keep an eye out for more of these live streams. They'll be on the HLD Lawyers YouTube channel if we can keep doing them this way. It might not be me next time. It might be someone else. It might be Mr. Brian Horlick if we're so lucky. And that's it for today, everyone. 45 minutes. I think that's great. What's the question here? How does that impact our message to residents? Yeah, so look, breaking news in the middle of our live stream. I think we're all going to read it very carefully, and we'll update our notices to residents accordingly. I'll take a look at what the mandatory quarantine means, but it's going to be whether it's more restrictive than what we already had in place. Should corporations be responsible providing preventative equipment for staff? If you can provide personal protective equipment, then try to do so. Yeah. But if you don't have it, you don't have it. It's going to be in short supply. And but yeah, if you can give people gloves, and if you can put people behind plastic plexiglass barriers, do it. Try. Okay, guys, that's it for today. Email me your questions. I will answer everything. And just stay safe out there, and keep self-isolating. Bye for now.